What happens if you have a Fifth Amendment right not to testify in Massachusetts? What if you get summoned for court? What happens if you get subpoenaed for court, but you have a Fifth Amendment right not to testify? How do you assert it? Well, it depends on your situation. So if you're the defendant in a criminal case, you have absolutely no obligation to testify at all. So you don't really have to assert anything. You just don't testify. On the other hand, you might be a witness in a case. You could be either the alleged victim or you could just be a witness to an alleged crime. And you might get a subpoena in the mail. So what do you do in that situation? What if the prosecutor or the defense attorney sends you a subpoena, you're the witness, and you think that you might be incriminating yourself if you testify? You might be admitting to a crime of your own. Well, what you would do in that situation is you'd either get an attorney if you can afford one, and the attorney would advise you what to do, and the attorney could make the right moves and instruct you. If you can't afford an attorney, you'd go to court and you would be approached by probably the defense attorney or the prosecutor, whoever summons you to court, and you'd tell them, hey, I think I have a Fifth Amendment right. And they wouldn't be able to advise you likely. Instead, what they would do is they would tell the judge that they've subpoenaed you as a witness and you may have a Fifth Amendment right. The judge would probably appoint you a court-appointed lawyer for the day to talk to you, to advise you whether or not you do actually have a Fifth Amendment right, and then to report back to the judge if you do have a Fifth Amendment right. And then from there, the judge can either accept that, or if one of the parties objects, the judge can have a hearing. They call it a Martin hearing or a Luman-Martin hearing based on an appellate case. And that hearing would be out of earshot of anyone. Usually the courtroom is cleared, and typically it's just the witness, so you if you're the witness, the attorney that you've been appointed, and the judge and the clerk. The parties are usually outside of the courtroom, and the record would be impounded, so it wouldn't be available to the public. And what would happen is the attorney that was appointed to you or who you've hired would basically say to the judge, here are the reasons that we believe there is a valid Fifth Amendment right. And if the judge agrees that there is a legitimate Fifth Amendment right, the judge would excuse that person from testifying and say, okay, there's a valid Fifth. Do you plan to invoke your Fifth Amendment right? And if the person does want to invoke their Fifth Amendment right, then they would be no longer obligated to comply with the subpoena. They would be free to go. But it doesn't always stop there. It depends on whether you're in district court or superior court. This is all for Massachusetts state courts. So in Massachusetts district court, it's pretty much the end of the story. If you're in Massachusetts superior court, the superior court district attorney's office can either accept that you've got a Fifth Amendment right and you're not going to testify, and that's the end of the story, or they can seek to immunize you. And this can be done with or without your consent. They don't need your permission to immunize you. They can impose immunization on you. They can say to themselves, I want this person's testimony so bad that I'm willing to get them to testify and absolve them from any risk that what they testify about is going to harm them. So they're basically saying, whatever you testify about under oath, you're protected. Whether you admit to a crime, whether you admit to the crime that the other guy's charged for, you can't be charged for that testimony. So as long as you testify truthfully, you are not in any danger of implicating yourself because we can't use the testimony against you. We're agreeing by imposing this immunity that we're not going to use it. So you may have situations where you might not want to testify, you might have a legal right not to testify, and yet you could be granted or imposed immunity and still have to testify. Again, it's always good to consult with the lawyer. This is just general advice, so please make sure that you contact an attorney if you're in a situation like this and you don't know what to do, and the attorney will be able to best advise of what your options are and how to best get the result that you want. So if you're in a situation and you've gotten a subpoena, but you don't want to testify or you're concerned about testifying, then you should consult with an attorney. This is just general feedback about what the process is. This is not legal advice. Every situation is different, and an attorney really needs to analyze the facts of the case versus the laws that you could be potentially implicating yourself for and advise you properly.